officer. I want to touch on three different areas. I want to start with the Rosen affidavit because it states in pertinent part there is probable cause to believe the reporter has committed a violation of the Espionage Act. And this is the phrase I want to focus on. At the very least, either as an aider and abettor and or a co-conspirator. If the standard is probable cause, why in the world would the affiant add the phrase at the very least if they weren't contemplating a prosecution?
I don't know why the person would have added that statement.
Well, you were a very distinguished federal prosecutor. I was not at all distinguished, but I was a prosecutor. I don't remember ever adding surplusage, extra wording to an application for a search warrant. So I'm vexed by why the affiant would say at the very least.
I just don't know.
Also in the application for search warrant, they requested a nondisclosure order citing the 5 different reasons. Now, it was my experience, and I assume yours, that the affiant is under oath when they appear before a judge.
Yes.
Do you know which of the 5 categories that would need to be shown for a nondisclosure order was testified to in this case? Which of the 5 reasons statutorily that you can seek a nondisclosure order were at play?
I'm not that familiar with the facts to be able to answer that.
But you would agree with me that when you're before a judge and you are swearing out your affidavit, if you're asked for a nondisclosure order, you have to have sense that one of those 5 factors is in play.
Well, I'm not all that familiar with the statute. I will say that when you file an affidavit, everything in there ought to be accurate, and you ought to be prepared to swear to every item in that.
All right. Do you ever recall discussing the Rosen investigation with the Attorney General?
No.
Do you know, well, let me ask you this. If the affiant said at the very least there is probable cause to believe a crime has been committed, was there a discussion of indicting Rosen?
Not that I had.
If you had more than probable cause, why would there not be discussion of indicting?
Well, there may have been discussion, as you well know, with the Assistant United States Attorney and the agent in terms of what went in the affidavit. You've done any number of hundreds probably of affidavits yourself, and the discussion between the lawyer and the agent is for the lawyer to get what the agent knows in the course of the investigation and get it written up so that you get the approvals that you need. I'm sure that happened here. Does not come up to my level to have that kind of discussion.
All right, so it is fair to say that you were not part of any conversations with respect to whether or not something along the lines of an indictment should be considered for the reporter, but you do not know whether or not the conversations took place. But you yourself were not part of them.
I was not and had not.
Okay. Does the Bureau have a policy with respect to shopping judges or not shopping judges? If you go to a magistrate or you go to an Article III judge and you're denied, is there a policy within the Bureau on judge shopping?
No.